Hi, my name is Greg Cirillo. I'm an aviation attorney and founding partner at HCH Legal, which is an aviation law boutique based in Potomac, Maryland. This is one in a series of briefings on top issues in aviation law, in particular business aviation. The topic we're going to talk about today is illegal charter, which is more of an initiative to squelch illegal charter. What's really relevant about it is that most people don't go into the illegal charter business consciously. What happens is they're going into a multiple operator structure, an owner and a lessee or two lessees, and they stumble into an illegal charter situation because they didn't structure it properly. This will be a quick briefing to identify what the top issues are and how to remain between the rails. Not a full legal seminar on it, but I'll try to keep it to under 30 minutes, and hopefully it will provide you some guidance to get you to the next level. Thank you. I'm going to talk briefly about how legal issues should factor into your business decisions. Legal issues are a question of risk, and risk has two basic components. It's the likelihood of it happening and the magnitude of the harm that it causes. So we'll talk about the likelihood of getting in trouble and the consequences of it as we get into the specific facts. But in terms of what I tend to do is I need to understand what the client's risk profile is, because under the current environment, the way the law is being interpreted, there is almost no zero risk option. Everything has some risk, and you need to adapt your operating structure to address the risk to the limitations that the client might have. Now, where I do draw a line is anything to dealing with illegality, risk to life or property, or reputational harm. And in the arena of illegal charter, those things are real risks. At the far end where there are illegal charters taking place, they are essentially unsafe operations. So at some point, legal advice has to be more definitive. And on rare occasions, I have simply said, we're not going to do this, at least not on my watch. So it's something to keep in mind. So what is a legal charter? Obviously, the easiest answer is it's whatever the FAA says it is. But to make it actionable advice, it's good to remind yourself that the FAA DOT see civil air operations in two basic categories. One is the owner-operator, which we think of as Part 91, and the other is air carriers, which is a 135 operation or a Part 121 airline or 129 foreign airline. And so for obvious reasons, the regulatory agencies put a much higher burden on anyone who's going into the business of providing air transportation, on the theory that an owner-operator should be given more leeway because they are protecting their own interests and lives. These differences apply and they affect the flight crew certifications, the equipment itself, and the actual operation, things having to do with runway length and crew duty time. So it is harder and it's more expensive to operate as an air carrier, and that's because it has to be safer, and that's what the FAA and DOT want to see. So what is a legal charter? Well, we're going to get into the details of how the FAA looks at it. I don't think anyone who asks that question is really intending to engage in it. I think it's just something you don't want to stumble into and have to extricate yourself from. I'm not going to spend a lot of time talking about the easy cases, the charters, the illegal charters that are obvious, because someone who's doing that probably is not interested in a presentation like this. But it's fairly easy to spot. The more it looks like a charter, the more it is a charter. It can involve a high volume of operations, a variety of unrelated dry lessees and passengers, and an active marketing promotion activity associated with that. These are situations where you've got FAA consequences, obviously, for both the the operator of the flight and the flight crew. But if there's ever an incident on an operation like this, you have a very likely possibility of not having insurance for either the hull or for liability. And at the very, very high end of illegality, you have criminal prosecutions. As I said previously, people who set out to engage in a legal charter are not the target for this presentation. What we often find is that the people who face legal charter questions are innocent violators, people who are trying something that they thought in good faith worked when it didn't. And it's a natural consequence of wanting to make Part 91 operations more efficient by having more than one operator on the aircraft to distribute the ownership and the capital costs and the operating costs among multiple people. So it's a question of finding out where the line is based on what your operating profile is. And the line can be difficult to spot. It's getting increasingly difficult because the FAA has been very active and has been moving the line significantly in what they consider questionable charter activity or questionable dry lease activity. And in addition to the FAA moving the line, the propagation of FAA policy throughout the country has been varied, and there will be very different interpretations of these rules in different jurisdictions. And you don't know what jurisdiction will be interpreting it for your particular operation. We're going to go with the basic fact pattern just to hang all of our discussion on, but the general principles apply to all operating structures. We're going to start with the idea of an owner that wants to lease out its aircraft, wants to engage in a dry lease of the aircraft for the obvious reasons, for efficiency and spreading the cost over multiple users. Best case scenario, you want to do it legally. You want to make sure that dry lease is also under Part 91. The FAA's position is it's under Part 91 if that dry lessee has operational control of the aircraft. You can start by looking at what the FAA regs, 14 CFR 1.1, say operational control means. And the regs say it means the exercise of authority over initiating, conducting, or terminating a flight. That's it. It's fairly simple stuff. And of course, there have been interpretations of that in the wild. And the FAA recently published an advisory circular called 91-37B that is an effort to help the general public and the FAA's own FSDOs in applying this very broad definition of what is operational control. What the advisor circular does is it drills down on what it means to be initiating, conducting, or terminating a flight, and it's a much broader set of activities than you would imagine. One of the things it starts with is a list of 3 key elements that determine who's in operational control. First is the lessee responsible for selecting and qualifying flight crew? Second is the lessee responsible for the airworthiness of the aircraft by tracking and performing maintenance? Third is, does the lessee manage the aircraft operations, such as monetary and logistical issues relating to the aircraft's use? You can see we've already gone fairly far down the road of what is initiating, conducting, or terminating a flight. The circular goes even further and asks 7 questions that the circular says, quote, clarify who will remain in operational control. So it's unclear whether these are all required or are just clarifications. These would be questions that you would be asked by a FSDO if you had a ramp check. 1, who assigns crew and does flight planning? 2, who do the pilots work for, which is an extension of what we said above. 3, who's maintaining the aircraft and where? 4, who ensures compliance with regulations? 5, who makes maintenance decisions and who directly pays for it? 6, who directly pays for fuel? 7, who directly pays for airport fees, hangar, food, and ancillary costs? Think about that. We're now talking about who pays for food, and the FAA believes that somehow relates back to who has authority for initiating, conducting, or terminating a flight. 2 takeaways on the advisory circular. First, they use the word directly very intentionally. They just don't want to know that a dry lessee is paying for maintenance. They want to know that a dry lessee is paying directly maintenance, meaning directly to the source of the maintenance. That raises a lot of questions because obviously in a multi-user environment, whether it be one owner and a dry lessee or 2 dry lessees, and particularly when you think of a maintenance program, you can't have multiple accounts. You're going to have one account. We'll get into it in more detail later, but what you're going to find is the lowest risk structure for multiple ownerships basically requires that you have some form of a management company that deals with each of the operators, because then the payments can be made to the management company on behalf of the operator and then paid on for maintenance, for insurance, for fuel, whatever it is. And you have a much better argument that you made that payment directly. But if you as a lessee are paying the owner of the aircraft for maintenance, for example, and the owner is paying, then I believe the FAA would say that you did not satisfy the requirement that you pay directly. So how do I advise somebody when I know that complying with all 7 of those points is virtually impossible? Well, it's going to be a balancing of risk and reward. You know, how important is it to have multiple operators, and then structuring the multiple ownership so that you take out the highest risk elements. And the easiest one to start with is the flight crew. If the lessee is not able to select, hire, fire their flight crew, and particularly if they're getting that flight crew from the aircraft lessor owner, that's not going to fly literally under any construct of the regs. That when the aircraft, I always tell myself, when the aircraft and the crew come together, it's going to be seen as a charter. So the lessee has to be free to choose crew, and again, that creates an interpretive issue, particularly with larger jets, where it's silly to have multiple crew on the same jet, and you're going to need to employ them anyway. But you can get around that by working with a management company. If the management company has the crew, that crew can be made available to multiple operators under separate arrangements. It gets very difficult, more difficult when the crew is an employee of the owner and the owner is trying to get that crew hired by the lessees, because if you dictate how the lessees hire crew, and they're going to hire your crew and you're the owner, well, you're also engaged in legal charter. Other than the crew, the other elements I'd say are all of a far lower magnitude. If I had to put a number on it, I would say the crew is 80% and the rest is 20%. Maintenance would probably be the next one. The owner paying for maintenance and then charging the lessee for it is going to raise eyebrows and could get you. I'm not going to say every FSDO would find it to be a problem, but most would, because maintenance is such an integral part of assuming responsibility for a flight, and it does relate back to the original CFR that says initiating, conducting, or terminating a flight. And that brings me back to the management structure. And when I say management, a managed aircraft, it doesn't have to be one of the major management companies. It simply needs to be an independent entity that is engaged in management of a Part 91 aircraft. And if that management company is authorized by each of the operators, the owner and the dry lessee, to subscribe to maintenance programs and navigational software, fuel, insurance, and you're in a much better position, if questioned, to show that each of the operators has contracted for that. They are doing it through their agent, which is the management company, which happens to be in common. So at the end of the day, the advice will be based on the client's risk profile, and we'll try to achieve the highest level of compliance within that profile. I think there are elements of compliance that go beyond the circular. In fact, I'm surprised the circular doesn't say anything about them. For example, if a client says, I want to do a dry lease, we're going to price it by the hour, and this guy only needs it during Super Bowl weekend. That, no matter what else you do with your lease document, that sure looks like a charter. It's the pricing model of a charter, and it is of such a short duration that it really starts to look way too much like a charter. So it's, but the circular doesn't say anything about the duration of leases, the pricing model of the leases, or the frequency of lessees. And those are when I talk about the ones that are clearly over the line. These are the dry lessees that have 4, 5, 6, 7 lessees in a given year. That's a lot of churn, and looks a heck of a lot like charter. Hard to avoid that conclusion. So let's say you got your good advice and you made your lease say everything that it should say. Does that solve your problem? Well, the answer is no. And there's a recent case on this. It's a US v. King. As it was a 2021 case that resulted in a $240,000 fine against an operator. We'll get more into the facts of that case later, but the point for now about that case is that that lease in that case said everything right, but practice did not follow the language of the lease, and in particular the crew selection clause, while perfectly drafted and compliant as drafted, was not followed. And while it said that the lessee could choose crew, in fact, the lessee never chose crew. The lessor chose crew, and in some instances, the lessor was the crew. Well, let's go through this as an example, a fact pattern that clients will come to you with. They want a client that owns an aircraft wants to add one or more dry leases to it. First question is always, how many dry leases is acceptable? And it's a tough answer. I can tell you that one is. I can't tell you when you reach the upper limit. Back in the day before Part 91K was adopted, there were multiple lessee structures. And in the early days, obviously 91K acknowledges up to 16 individual owners and 16 individual operators operating under Part 91. By no means does that mean that you could, any given owner could have 16 dry lessees. There are other elements of Part 91K, particularly in the management side and the obligation to have certain charter-like programs and manuals that justifies it. But so with 16 too much, 1 is fine. It's somewhere between 1 and 16. That's where it gets difficult. People want to know what's too many, and you have to look at the individual facts. How well are they able to truly manage this? One being, of course, if there is a management company involved, getting 2 or 3 and having truly convey operational control to those is possible. But at some point, it will become implausible. As I noted, though, the advisory circular doesn't actually identify the number of lessees as being a problem, but I think it would be. As I said at the beginning, Getting through legal issues is a question of measuring risks and rewards. And clients are going to want to have multiple operator environments. So you need to understand what are the probabilities of getting in trouble and what are the consequences of it. Best case scenario, you come up with one or two dry lessees and you put it together in a multi-operator structure that is as tight and well documented as possible, and the operations actually follow what the documents say. You can advise your FSDO of what you're doing. You will obviously tell them about your dry lease. The FSDO may or may not take a look at your dry lease. They may send it to the DC office of the FAA, but you've done as much as you can at that point. What's useful to look at, and I'm getting back to that King case, US v. King, is that case shows how it all blows up. In that case, it was a ramp check away from the home base. So who cares if your local FSDO was okay with it? You can get a ramp check away from your home base. And by all indications, that somebody dropped a dime and said, hey, these people I think are operating an illegal charter. And I assure you, there's the whole industry of people out there that want to stop illegal charter. In the King case, the lessee had signed a lease that said everything right. It was honestly the kind of lease that I would have put together for someone. And the lessee certainly was just an innocent person tangled in this mess. But they obviously had their flight canceled and ended up caught up in this litigation because the FAA actually referred it out to the Department of Justice to litigate, probably to make an example and to create this case law. The court looked at the 7-point test that the advisory circular published and found that the arrangement was lacking. Now, the court didn't come out and say that you have to meet all of those standards. It doesn't say that you don't have to meet all the standards, so it didn't clear that up, but it really did focus on the one issue, and that is the flight crew. Because in this case, what happened was the owner of the aircraft, while saying in the lease that the lessee is free to choose pilots, in reality, it was forced, and the situation was almost coercive in that it required that the owner's pilots be used, and including the owner himself as a pilot. And so, of course, it was kind of a slam dunk when you fail on that element. It would have been interesting to find out if they didn't fail that element, but then we're being tested on some of the others. But we'll never know. Takeaways from the King case. One, the FAA is dead serious, and the legal charter industry, the non-illegal charter industry, is pushing really hard to squeeze this activity out. What seemed okay just a few years ago, and frankly, advice given by myself and others, is no longer okay. You can't paper over a bad arrangement with a good lease. You have to follow the lease. And as I said, there is no zero risk circumstance, because at some point, I don't know how a dry lessee can be responsible for hangarage when the owner is responsible for hangarage. So there will always be risk. It's a question of how much there will be. Lessees don't face serious penalties themselves because they are not regulated. They don't have a pilot's license. They don't have an aircraft registered. They are just illegal charterees, if you want to call them that. But they will be dragged into investigations, and they will have to respond to a bunch of questions that they don't want to respond to. That's not what they got into this for. So it's trouble even if you're not a lessor or a pilot. And as on that topic, pilots can face a separate enforcement action for flying in a commercial operation without proper certification. So what do you do when a client or a customer comes to you looking for dry lease options or looking for your input on whether to go forward on a dry lease? First thing I do is you go through the conventional options that are either within safe harbors or otherwise simply not going to create a problem and will possibly resolve the client's needs or opportunities. First is, of course, time sharing an aircraft. It does allow users with limited amount of reimbursement. It's not really set up to defray costs of ownership, but it's more a question of getting the aircraft into other people's hands and usage. And again, you have to follow the time share rules. One of the main things to be aware of is just because something is a timeshare doesn't mean it's legal. If you tried to run a business following the timeshare rules very carefully, but you ran it like a charter business and you held yourself out there to the public as a source of air transportation, then it doesn't matter that you comply with the time-sharing rules. You still engaged in illegal charter. Second thing is joint ownership. A direct owner, more than one direct owner can get together and one of the owners can be made responsible for managing the aircraft and sharing costs. When you have the right situation, this is a great way to get what you need, which is the sharing of ownership costs by literally sharing ownership. Again, that's another area where it has to be realistic. You can't have people owning 1% of your aircraft. You want to show a bona fide effort to jointly own the aircraft. The last one that nobody wants to hear, the last solution is just put it on a 135 certificate. Let someone else charter it, and then leave the safety and risk to someone else. But obviously, we know the reason we have a legal charter is because the owner will not get what you would get if you dry leased it. So if you've exhausted the easy options and client still wants to do a multiple operator environment, dry lease environment, then you just have to balance the risks with them. Let them know that there's always going to be some lingering risk. I think I'm getting to the point with my advice that I think you need an intermediary company so that the maintenance and other factors can be truly directly paid by each of the operators. And then you make certain that the operation actually follows the language of the lease. I'll tell you, I've been on the lessee side of some of this, where a client comes to me and says, we want to do a dry lease. And a couple of times it was really problematic. And I could tell that whoever had put it together, they knew what the lease should look like, but it wasn't going to function that way. And in that context, I will tell a client that there's a reason why there are charter operators, and it's for your safety. And while it might be nothing more than a hassle to deal with an FAA investigation, and as a lessee, you're not going to be on the hook for penalties, all that goes out the window if somebody gets hurt or killed on an unsafe operation. So I try to dissuade clients. I tell them the problems, but I'd be lying if I said that clients sometimes don't listen to me. So thanks for hanging in there. I kept it under half an hour. I hope it wasn't too bad. Always open to questions. Again, as I said, this isn't legal advice, but it is guidance. Would love to help you out if you have anything that needs to be looked at more deeply. I also hope that that this might resolve some of your issues without needing legal help. Again, HCH Legal, aviation law firm based in Potomac, Maryland, with operations, clients all over the country and the world. And we are an aviation boutique with a primary focus on business aviation. Thank you.